Thank you. Please be seated. Good morning. We're here for oral argument in case number there it is. Sorry, one CACV 160673. John G. HOLM, MD et al. Versus Gateway Anesthesia Associates et al. Counsel, just reminded these proceedings are being video and audio recorded, so we'd ask you to please identify yourselves and your clients at the beginning of your argument. Each of you will have 20 minutes to present your arguments. Appellant's counsel, you're responsible to watch the clock and retain as much time as you deem appropriate for rebuttal. Also, please keep in mind we've read the briefs and have discussed this case at length in conference. With that, counsel, you may proceed.
Good morning. Brian Bueller of Sherman & Howard on behalf of the appellant's Gateway Anesthesia. So my opening brief talks about 11 different issues, including various different jury instructions, and I have 20 minutes, which includes time for rebuttal, so I'm not going to go over every single one of those. And what I'd like to do and talk to you today about is what happens next. Starting with what happens next if the entry of partial summary judgment for reformation is set aside. What happens next? Does it get sent back to the trial court for redetermination? And the answer to that is no. And the reason that it doesn't is because we also filed a cross motion for summary judgment for reformation, and plaintiffs had two requirements that they had to show, not one or the other, but two: mutual mistake and a meeting of the minds, and they didn't do either one of those. And I'm not talking about whether they submitted clear and convincing evidence to justify their position. I'm saying they didn't have any type of evidence. So
you're saying there's no factual issues whatsoever regarding?
No, they're not. And the reason that I'm saying that is, which you look at a four-day trial and all these paperwork and all these things, well, there's got to be a factual issue. Well, there isn't. And the reason I say
that. No, but wait, time out. You're talking about summary judgment.
Yes.
So go back to, so you disagree that at the time of summary judgment, that would be our standard of review, right? We would review the doc. Okay, so there was no question of fact, no material question of fact that there was a reformation.
There was not.
The contract should be reformed.
There was not, because what they had to show was mutual mistake by both parties. They submitted evidence of what their perhaps mistaken belief was.
Dr. Nottingham and I'm not sure how you pronounce Delicio?
Yes.
Okay. Both in their deposition testimony agreed that they were on board with what they were saying and did not have a different take on it. So how is that not mutual mistake?
Well, first of all, with regard to Dr. Nottingham and what was presented both at the trial court for summary judgment and in front of you here, was a deposition transcript in which there's a question, there's a partial answer, there's asterisks, and I've forgotten, but it's either 25 or 30 pages, and then they pick up the end of a second answer to a totally different question. That's not evidence of a mutual mistake. At what point in time is there anything from Dr. Nottingham, Dr. Delicio, or anyone saying, you know what, I was mistaken about that. This is a 16-page contract. I didn't mean that. I didn't mean to write that. Dr. Nottingham was.
Why did it need to be that specific, counsel? Why couldn't it be exactly like the trial court apparently viewed it, as that, look, generally speaking, I viewed this as they needed to be treated as partners. They were supposed to be treated as partners, and to the extent that the contract doesn't reflect that, that was in error. Is that not? Is there no evidence supporting that?
Well, no, there isn't, because what does that even mean? Paid like a partner. What does that mean? Because no one said what that definition is. No one talked about.
Wasn't there years of experience here that showed what paid like a partner, what meant?
Yes, I'm glad you brought that up. There was, and they were paid absolutely consistent with those years of experience. They are not saying that they weren't paid like a partner with regard to those years of experience. What they're saying is there were future revenue streams that erupted, that came into existence, and I wasn't paid like those guys. For example, the contract physician, Dr. Spangler, they'd never had contract physicians before, ever. And so afterwards, they hired one, and they didn't share in the revenues of that contract physician.
But they did share the costs of that physician, correct?
Yes.
Okay. And so how is that treating all of them equally?
You've just used a word that was not included in any of the discussion. You just said equally. You are equating paid like a partner, which is what the trial court evidently did. Paid like a partner means everyone will be paid exactly the same amount. Well, that's not what happens.
Let's turn it on its head. Paid like a partner means everyone will be paid equally. You took umbrage with that. So let's break it down even further. If, in fact, they were to be paid like partners, and a doctor that had been there for 10 years was a partner, which I know they weren't even, Dr. Nottingham, let's take him.
Sure.
He gets part of Dr. Spangler's revenues and pays his costs. And then we have Dr. HOLM over here who is to be paid like a partner. How is that not equal? And I'm not sure why you're having such an issue with equality when we talk about paid like a partner.
Well, it's the example that I made in my brief, and I'm going to make it again. And I presume you all are experienced with that. Every partner in a law firm is paid like a partner. You're not paid equally. You have different factors that are included. I mean, paid like a partner, you're equating with equal payment for all. And what I'm saying is, at the very, they never discussed that. That was never a meeting of the minds as what it is. What Dr. HOLM and what Dr. Weiss might have thought that meant is really irrelevant because they never talked to anyone about that. They never expressed to anyone that that was what their intention was, or that was what the agreement was. And they have to show mutual mistake. We didn't mean to say that. And second, we have a complete meeting of the minds as to what paid like a partner means. And it wasn't. In the example that I gave in the Court of Appeals, and I don't have it in front of me, but I'll give you a minute. There was an agreement between parties that's saying that it will be proper releases. And later they turned out that the court, the district court, the circuit court said no. There was never a meeting of minds of that. And I guess what my point of this is, there was never a discussion about what paid like a partner is. And so how can there be a meeting of the minds if there's never a discussion? Everyone's equating paid like a partner is the same as paid equally, paid exactly the same. And if you don't have that discussion, you can't have that meeting of the minds.
Counsel, I'd like to ask you about another motion for partial summary judgment, and that would be regarding the buy-in fees.
Yes.
Could you please explain why that clause, why paragraph 17 is not ambiguous? Why did the court err, in your opinion, of saying that that was ambiguous and needed to be interpreted by the jury? and let me get even more, a little bit more specific. Regarding the first clause, which I would say if you're terminated for any reason before the 2 years, and then the second clause, what I'll refer to as the second clause, if you're still around at the 2-year anniversary, then it seems to say, it says, however, he shall not be responsible for paying any of the, and then in brackets, buy-in fee, of the fee, the buy-in fee. It seems to me that you've got two conflicting provisions. Am I wrong on that?
Well, I don't read it like that. I understand that you think that, but when I read it, let me answer your question, though. Why that there isn't a ambiguity there? If there's an ambiguity, and let's presume for a moment that I will give you that, and I don't accept it, but let me just say, sure. Presume if there's an ambiguity, so what next? You're going to go to extrinsic or parole evidence? There is none. None of the parties talked about what was going to happen after they left. Nobody talked about it. There is no extrinsic or parole evidence that can be used here because all you can do is read it and see what it says. And what, in my mind, what it doesn't say is, by the way, you get all your money back. There's never any mention of that in that paragraph.
What about the fact they were told they were going to be partners?
Glad you brought that up.
That would be extrinsic evidence that could tend to show that they thought they were going to be partners.
Absolutely.
And that they would reach the 2-year anniversary.
And if they were making a claim, which they were asked repeatedly, are you making any claim the fact that you weren't made a partner? They always said no. So that's not part of it. Are you suing them because you weren't made a partner? No, but I should get my money back because I wasn't made a partner. Well, wait a minute, that's a claim for not being made a partner. So if they've already said that that's not what's happening.
But that was their claim for wrongful termination.
No, that was their claim. I asked a blanket statement, are you making any claims? And they said no.
Is there any reason under this buy-in clause, this paragraph 7, is there any reason why the 2 doctors would be treated differently? I mean, because in the sense that one was terminated, one, I believe, left voluntarily.
Well, that's another good question, because it's something that the trial court didn't understand, and I don't think these are 2 separate cases. What happened to one is not what happened to the other. The fact that one's entitled to something does not mean the other's entitled to something, because all of the facts are different. These are together by convenience. They didn't talk to each other. They didn't even know each other until after they signed the agreement. So whatever happened with one did not happen with the other. So whatever happened, or one was terminated before and one was not, you can't put the confluence together and say, well, because this happened to this, something happened. So in answer to your question, in my mind, when we talked about what termination is, both were terminated before the 2 years. They were both told, you're not coming back. So, and that's undisputed. You're not coming back. Dr. HOLM has said you can work through. Dr. Weiss left. That's the best evidence that he was terminated before 2 years.
Okay.
Dr. HOLM,
Based on the record I have before me, I thought Dr. Weiss left with the blessing of Gateway once Gateway informed Dr. Weiss that he would not be offered a partnership.
Sure.
So he left with the blessing of Gateway.
Well, and I guess I don't understand what you mean by blessing. Can you want to leave early? Sure, you can leave early, but you were still told you're not going to be a partner. You need to find someplace else to work. You want to find, you have a contractual obligation to work through a certain date. You want to leave early, that's fine. I mean, because it is a 2-year with a notice provision. So yes, you can leave early. We're not going to hold you to the contract. If you have a great opportunity, go for it. But that doesn't change what the statute says, or I mean what the paragraph says and what his circumstances were. Both were told, I'm sorry, this didn't work out for us.
Okay, now, will you bring in, now I'd like you to bring in, or I'm going to ask you to bring in breach of the implied covenant of good faith and fair dealing as it relates to this same, of course, this paragraph, which seems to be important. And so
it's really
how
important.
does that went to the jury, right? That went to the jury. So 2 things went to the jury, if I recall correctly. The breach of contract, either breach of paragraph 7, and then breach of the implied covenant of good. I'm just going to call it bad faith. Sure. The bad faith claim.
Sure.
Right?
Yes.
Why? I mean, the jury found on those things. Why in the world would we set that aside?
Why did they find on those things? They found on these things because there was one paragraph that was at issue here. One paragraph, paragraph 7. That's a half-day trial of what does that paragraph mean. And we had 4 days of testimony and a half-day trial of paragraph 7, and then we had 3.5 days of all the other bad stuff that Gateway brought in. And that's that whole 404 problem. So did they find bad faith? Yes, because they were constantly told for 3.5 days what terrible people Gateway were. And so they didn't act in good faith, and look what happened. And as a result, it just got transferred over to paragraph 7. That, sorry, it was exasperating then. It's exasperating to talk about now. But that's why they found that. But that's the whole purpose for Rule 50, to say, listen, there is no basis for good faith and fair dealing because that requires some discretion, and you're either entitled to your money under paragraph 7 or you're not entitled to your money about paragraph 7. There's no discretion here. It's not, paragraph 7 either requires me to pay it or not. It's not well, I'll pay it if I feel like it. There's no discretion, and that's why good faith and fair dealing has nothing to do with paragraph 7, and that's why my Rule 50 motion as to that issue should have been granted, because what's the discretion? I still haven't understood what it is.
Assume I agree with you that good faith and fair dealing should have been granted, that Rule 50 motion should have been granted. How does that help you?
It helps me because the whole case is going to go back because the Rule 404 violations, at the very least, we're going to retry paragraph 7. And we're going to
assume I disagree. Assume I disagree.
I understand, but I'm just telling you.
I guess what I'm saying is that it doesn't change the jury's verdict on the breach of contract.
It does not. Okay. It does not. But
let's go back to your Rule 50 motion. You moved for Rule 50 relief, and once the jury returned the verdict, what specifically did you do to preserve that?
I'm sorry, I don't preserve.
Move for new trial?
No.
Okay.
But there isn't any mandatory new trial requirement. So
okay.
I was in front of a judge that had ruled against me consistently for months. I wasn't going to spend any more time and effort of my client's money doing something that I knew was not going to happen, which I knew was not required.
Okay, let's back it all the way back to the summary judgment motion on paragraph 7. We've read the transcript. There's a lot going on there. When we talk about that summary judgment motion before the court, you think the court did not have sufficient evidence to deny your motion?
Yes.
I was a little unclear on your argument in your brief.
Yes.
So explain that to me.
Why my motion for summary judgment on paragraph 7 was improperly denied?
Yes.
Okay. For the very reason that I just, well, because there's no evidence. It's, I'm not saying this correctly. It's a legal conclusion. The province of interpreting and construing a contract is in your lap. It's in the trial court's lap, unless there's some factual evidence that you need to talk about. And in this case, paragraph 7, there is no factual evidence to talk about because no one talked about paragraph 7. No one said, here's what's going to happen when you leave. No, it's a vacuum. It's a factual vacuum. And so what you're left with, and if it were clear, right, there wouldn't be any question. But we deal with the facts that are given to us, and the contract says whatever the contract says, and that's what we have. And so we have to look at it and say, what does that mean? And that's the trial court's job, and that's your job, because there is nothing else to consider. And so you have to look at it and say, okay, is he entitled to get it back or not? And obviously I'm saying he doesn't because it doesn't say that. But again, that's the court's job and not anyone else's. And they tried to make it the jury's job. And again, that whole 404 thing. So there. I have less than 3 minutes to go, so I'm going to try and save that up.
Thank you.
Good morning, Your Honors. Tina Ezel with Tiffany and Bosco for the plaintiffs, Dr. John Holm and Dr. Lee Weiss. First of all, let me say, this is not my favorite thing. I get nervous, and I'm sure Mr. Mueller, we have known each other for many years now, knows this because you've seen me fumble many times. But I'm going to jump right in here because I have limited time. I want to first address the issues that the court just asked about because I'm assuming that those are most important to the court. I could give you my prefabbed oral argument, but I think I want to focus in because you had questions. So the first question, I'm going to go in reverse order because it's fresh in my mind, was about the good faith and fair dealing contract. So one of the misconceptions of Gateway is that if the contract doesn't expressly prohibit conduct, then it can't, taking that conduct or making that action can't be a violation of the covenant of good faith and fair dealing. That is absolutely contrary to Arizona law. What Arizona law says is that the covenant of good faith and fair dealing is implied in every contract, and it prohibits any party from taking action to deprive the other of the benefit of the bargain they made. When Mr.
Counsel, that sounds like any time that money's not paid, you'd have bad faith claim.
I understand that. So that's why it's important to look at the actual evidence, the overwhelming evidence that was submitted both to the trial court on the motions for summary and then, of course, to the jury. And the evidence was, and it's in the briefs and it's in the appendices, and that was this, that there was no discussion what happens if we don't make you a partner. Do we get to keep your money? There wasn't a discussion about that. Very simple reason for that. They were told they were going to be made partners. The overwhelming evidence that really carried the day here in this case, Your Honors, was that every witness, including Gateway's own witnesses, testified that when they did discuss the buy-in fees with Drs. Holm and Weiss, they told them that the purpose of those buy-in fees was to advance pay for a membership into Gateway. If you read the paragraph or section 7 itself, you certainly get that impression, but because there is that ambiguity about if you're if you're just not made a partner, you're not going to be responsible for paying any of that fee. Because of that, this evidence became very important. What was the party's intent with regard to that buy-in fee?
There.
Sure.
Walk me through why this is ambiguous, because what I'm seeing in paragraph 7 is two clauses. First, if you're terminated prior to the completion of 2 years for any reason, you forfeit the fees. If outside of that termination, if you don't become a manager for any other reason, implying voluntary, but for any other reason, then you're not responsible for paying the fee. Why is that ambiguous?
So, first of all, use of the word termination is not defined. And I think that the evidence was undisputed that they weren't, at least initially, no one was terminated. They were simply told that the contract was not going to be extended and that they ought to go look for other employment because they weren't going to be offered membership into Gateway. They weren't said, you're fired, you're terminated, you did a bad job.
Employment is terminated. Not just your employment is terminated for any reason.
It's not terminated because you're only allowed to work to 2 years.
What's the common definition of terminated?
I think when most people, and doctors are most people because they're not legally trained, I think when they think about being terminated, they think about being fired. In this particular case, I'm not trying to put too fine of a point on it, but in this particular case, these doctors had the right, by contract, to work exactly 2 years. That was not terminated. That was their employment. It wasn't terminated. They were told it would not extend beyond that. They had an option, the parties had an option to extend it, but they only had the right to work for those 2 years.
So your position here today is that neither doctor was ever terminated?
No, that's not exactly the position. So initially they weren't terminated. Subsequent to Dr. Holm asking Gateway to refund both doctors asked for the buy-in fees to be returned because they didn't get what they paid for. They were told, this is to buy a membership. We didn't get it. Please give us the money back. That's when Gateway said, oh, well, in that case, you're fired, to Dr. Holm. Dr. Weiss had already left or was on the verge of walking out the door because they had agreed to modify the term of his employment. They had agreed that he could leave early. So Dr. Holm was, in fact, terminated by Gateway. However, that's one of the reasons why it was important for the parties to explain to the jury the past dealings and goings-on between the parties, this Rule 404 stuff, because we couldn't tell, the plaintiffs could not tell at any given moment whether Gateway was going to argue to the jury that Dr. Holm was legitimately terminated or whether it was going to just say, okay, well, we're not going to use that termination, which we were saying all along was wrongful. Breach of...
Matter whether or not it was wrongful?
It does, because you can't... it's not a good faith adherence to the bargain the parties made to say, look, if you're terminated, you don't get this, we're just going to trump up some charges so that we don't have to pay you. Not because we actually don't want you working here, because the testimony was that they still desperately needed him after they let him go. They had to hurry up and everybody had to cover shifts and I had to hire all these new doctors. seriously. So it was
All this testimony you're referring to, this is all in the summary judgment record? Because I think the only issue we're concerned about for this clause right now is the summary judgment motion. The Judge Duncan said there's a question of fact. And what I'm trying to figure out is why Judge Duncan said there's factual questions.
Okay. If you would allow me to get the copy of the contract.
Because, and then following up on Judge Perkins' questions here, I mean, I think to cut right to the chase here is that if Dr. Holm was terminated, I mean, that seems pretty crystal clear to me that if he's terminated for any reason prior to completion of the 2-year term, then he's not entitled to the buy-in fee.
So the covenant of good faith and fair dealing actually says, in Arizona, the case law says that you can actually still violate the covenant of good faith and fair dealing if you use discretion allowed to you under the contract for a reason not within the contemplation of the parties.
Let's look at the very narrow issue of Judge Duncan's ruling at the time.
So I distinctly remember it because what was happening was Mr. Mueller was arguing to the judge that if you're terminated or if you leave, you don't get any of the buy-in funds back. And I pointed out to Judge Duncan that if a physician doesn't become a member at the second anniversary, he can still get the same compensation, but he's not responsible for paying any of the administrative fee. Mr. Mueller's argument was that what that meant was he shall not be responsible for paying any further amount of administrative fee or any future amount of administrative fee. And I argued to Judge Duncan, one of the few successes I had with Judge Duncan, that if they had meant to say that you didn't have to pay anything going forward or for the future or any more, that it didn't say that and it wasn't clear. The doctors, not being trained legal minds, read that to be, well, you know what, if they just don't want to make me partner, then I don't have to pay any of that because it's an advance payment for the membership interest I'm buying. If you read this, if you look at the case in a vacuum without considering the representations made to them and just read that paragraph, it's still pretty compelling that the buy-in fee was to buy a membership, and therefore it was reasonable for the doctors, Holm and Weiss, to conclude that if they just weren't made partner, which is what they were told, they weren't being made partner, that they wouldn't have to be responsible for pay. Almost like an escrow account. It's being held there.
But what facts, I mean, to go back to Mr. Mueller's comments about what parole evidence was relevant to explain this paragraph 7?
So
I guess you probably say there's a lot, but give me a couple of examples.
Sure, absolutely. So, for example, all the doctors, and I think I laid some of it out in my brief, but the doctors, even gateway doctors, told my clients, and this was the evidence, that the purpose of the 20% and the 10% buy-in fees was for these doctors to pay for the partnerships that they were going to be awarded. So when they weren't awarded the partnerships through no fault of their own, their position was, and still is reasonably, that we didn't get what we paid for because there was never any agreement that this could be used for anything else.
Even though it says, and I'll quote it, should physician's employment be terminated for any reason prior to the completion of such 2-year terms, then he shall not be entitled to any interest in company or to any of the, I think it said administrative fees paid by physician to company as set forth here and above. And I believe administrative fees were defined as fine.
Right, and that takes us back to the word terminated. What does it mean to a layperson? It didn't mean to my...
Was that precise? Is that what you argued to Judge Duncan? The termination? Those arguments? Because this is a huge record, and I'm not going to lie to you.
It is a huge record.
And tell you that I've read...
And I'm not going to lie to you and tell you I remember every word I used in that oral argument. I can tell you it was transcribed, and so I believe it's in the index of record. If to be honest, I would have to look exactly back at it to see what I said because I don't remember what I said yesterday.
That's fair.
Where it is.
That's fair.
Yeah. Okay. Let's see if I can jump. How much time do I have left? 8 minutes. Okay. Let me talk about a couple of other things. So what is really so interesting about this case is that we never have anybody from the other side, from Gateway, ever saying that that Gateway ever meant to pay Doctors Holm, this is when they entered into the contract, that they ever meant to pay Doctors Holm and Weiss differently than they had represented and they had promised. You don't have that. In fact, what you have is Doctors Delicio and Nottingham saying, yeah, we told everybody this, yep. Well, I don't remember specifically what I said to Dr. Holm, but we told, this is kind of what we were doing, and yes, this is what we told everybody. I would submit to you that what Gateway relied upon in the prior about saying there's no mutual mistake was this idea that they didn't remember exactly what they said to Drs. Holm and Weiss. But if that's true, that they didn't remember what they said, but they don't remember saying anything opposite, that means that what Drs. Weiss and Holm testified to over and over and over through 4 depositions is the only evidence of what was told to them. And I think you probably already get this, so I won't belabor it too much, but this isn't a situation where one person said to my clients, we're going to pay you like partners, and then it's just up in the air about what that means. If you look carefully at the testimonies of Drs. Holm and Weiss, they both testified that it was described to them how partners were paid. It was described to them how money was pooled into 3 separate pools and how each physician would get this share or that share. It was described in detail. Then, after they got the contract, Dr. Weiss called Dr. Nottingham and says, and I'm paraphrasing, this is legal mumbo jumbo, is this what you promised me? And Dr. Nottingham, again, I'm paraphrasing, says, yes, it's what I promised you, except there's this 10% founder's fee. The partners felt we should reward ourselves for making such a great company, and so we're going to take 10% off of one of the pools for that. And Dr. Weiss says, you didn't tell me about that, but I'm good with it. I'm okay with it. I just want to make sure that this is what you promised me. And Nottingham says, yep, that's what I promised you. So if anyone from Gateway had said, look, at the time that we entered into this agreement, we didn't actually intend to do what we said we were going to do, which, by the way, there was no undisclosed intent by the doctors. It was actually verbally accepted, and it was also in writing accepted. But if one of them had said, look, we didn't actually intend to comply with that, what we really meant was that we would decide later on down the road how we would pay you, and that's that. Nobody says that. The reason they don't say that would be because it would be fraudulent inducement to tell my clients we're going to pay you this way if you're a doctor here, at the same time intending not to pay you this way. So I can't think of a more compelling case. Everyone's in agreement about what was promised for the pay.
Let's move on because
Sure.
we're running out of time to
Yep,
the
sorry.
404B information and the objection to the admission. And if you can pay special attention to the treble damage issues, how did you guys ask the court to answer that? And what was the agreement going in? Because your stipulation doesn't exactly say.
Okay, so right before trial, we were still thinking, all of us were still thinking that we were going to have to try everything to the jury. That means all the 6 components of wages. Were they wages? Was it in good faith? What was the dispute about? Right before trial, realizing the trial would probably take 3 weeks if we had to actually go through the calculations of damages, Mr. Miller and I discussed, let's just agree to the amounts, because once it's reformed and Gateway is held to have to pay them the way they promised, it's just math. So that's what we did. However, we also agreed that we would allow, we had asked for a jury trial. We also agreed we would allow the court, instead of the jury, after hearing the evidence at trial, to decide, were these wages, and was there a good faith dispute about the amounts owed? So that's what we did. The court was taking copious notes. It knew it had to make those decisions. We agreed we would brief it after the jury trial. That's what we did. We didn't have to submit any other evidence to the judge because we had we had just done it. I hope I answered the question.
What about the 404 objections or the argument that they did not make a proper objection to 404 evidence? Because in the reply brief, it seemed like they quoted a fair amount of something that happened the next day or the next morning or something. Why isn't that sufficient?
So, first of all, the Rule 404 argument wasn't really made until after some evidence had come in. So anything before that, I don't know how that could possibly apply. Subsequently, there was a general objection placed on the record to making them look bad. But there wasn't any specific objection to why a particular piece of evidence wasn't relevant or was 404B evidence. It wasn't specifically discussed. So, at least it wasn't discussed enough to make a full record and why it was relevant. So, for example, and this is just the easiest one. If you wanted me to talk about another one, I will. But Mr. Mueller objected generally to communications about or talk about discussions about being promised to be made partner. Okay, he said, or Gateway said, that talking about Gateway not making him partner after having promised to make them partner was a prior bad act that could not be given to the jury. Our position was, we're not asking to be made partner, and we're not saying they didn't have the right to make that decision. We're saying, having told us what the money was for, and having legitimately made the decision not to make us partners, you then have to give the money back. So the problem with most of the 404B argument is that had Gateway wanted to have a limiting instruction, it needed to identify the evidence that it claimed was coming in that could be prejudicial, and then it had to limit the jury's consideration of that particular evidence to legitimate purposes. And some of those purposes actually were contract intent. Gateway was claiming a variety of reasons why it didn't pay the buy-in fee. One of the last reasons that it was an evolving position, so it was really hard for us to understand. But one of the reasons it said it was taking the position that it could keep the buy-in money, for example, was that it had to, or it was supposed to under the contract. That's how it interpreted the contract. So some of this other evidence came in to show that no, that wasn't why Gateway was doing it. That wasn't a legitimate interpretation of the contract, etc. But the most important reason why the 404 argument is, I don't want to say it's not important, but the reason it fails is because that there's no indication that the jury's verdict on the buy-in money would have been any different, because the evidence was compelling that the only discussion the parties ever had about the buy-in fee was that it was to buy a membership in Gateway. So the jury would have found what it found regardless of the Rule 404B. But again, we submit that there was no appropriate limiting instruction requested. You know, and it's now after the fact that they don't like what happened that they say, well, there should have been a limiting instruction. Well, it's not the trial court's responsibility to write that limiting instruction. There was a little bit of issue with the case law because the 2004, now I don't remember, the case that we cited, the civil case, says that you don't have to have a limiting instruction. The criminal cases, which rely on criminal law and the due process afforded criminal defendants, says that in those cases you do. So I hope I've answered the questions. We could talk for days about Rule 404, but
Counsel, I see your time's up.
It is.
Do you have any other questions for counsel? Okay.
Thank you, Your Honors.
Thank you.
I'll talk quickly because there's something that's very important. I'm not a court reporter, but here is what she just said. Every witness testified that when discussing the buy-in fees, it was to be an advance fee to be made a partner. Advance payment. Respecting the 20% and 10% interest was to pay for the partnership that they weren't awarded. That testimony is not anywhere in the record before you. Nowhere. It wasn't in front of the trial judge when my summary judgment was issued, and it's not in front of this, in this brief, anywhere. So whatever recollection Mrs. Zell has, and I respect her, I'm not saying that she's intentionally saying, what I'm saying is if you look at the record, you will not find that anywhere. But that's the argument that they just told you was the reason for why the good faith and fair dealing is appropriate here. It's not. And you can't just come up with what you wished your clients had said, either at the summary judgment or now.
All right, I've got a question that I need. It's a burning desire. I need you to answer this. You entered into that stipulation. You stipulated to the amounts and you stipulated to the court finding treble damages.
I did.
You also stipulated, and I believe first day of trial there was a discussion about the fact that we're going to get into other things so that the court can, after the jury's dismissed, make the decision on treble damages. Do you recall that?
Yes, I recall all of that.
And so how does that not run afoul of your 404B argument?
So, the motion for summary judgment for affirmation, I have to go back to explain how we got to where we were. There was the Judge Blomo granted her motion for summary judgment regarding reformation and said it was going to be paid like a partner. I didn't know what that meant. I filed a motion for clarification asking what does that mean, and he still didn't tell me. I guess he thought he told me, but he still didn't tell me. And as a result, in my joint pretrial statement, in the initial jury instructions that I put in, I said, jury, it's up to you to decide what paid like a partner was. And it was at the it was at the final scheduling conference, just a few days before the hearing. Judge Blomo said, oh, well, no. Paid like a partner means this. It means that every partner will share equally in all the revenue streams. He'd never said that before. I didn't even know what that meant. So, if that's true, if that's his legal ruling as to what the party's relationship is, I disagreed with it. But if that's what the ruling is, Mrs. Zell and I can just do the math on that as to the various revenue streams. So that's how we got to the stipulation. It's like, well, if in fact you just found that they're supposed to share and we acknowledge we didn't share equally, I mean, that wasn't in a dispute. We were just saying we didn't have to. But if you're saying as a matter of law we had to pay everyone equally, then, as Mrs. Zell said, we can just kind of go through it. And
let's get to why you agreed to the court making the treble damage analysis rather than letting the jury.
Because I wanted, that seemed the appropriate way and seemed in my mind the way to avoid the whole 404B. You don't give that to the jury. It's not an issue for the jury to determine about good faith or bad faith. It's not. It's for the court, which is another reason, excuse me, why I was trying to avoid this whole 404B. I wasn't agreeing that that stuff was relevant. In fact, I was trying to avoid giving that to the jury at all by saying, Judge, you determine what good faith is. That way we don't have to have the jury hear all this other 404B evidence that isn't relevant. So that's why it was not a concession. It was trying to limit the evidence going to the jury and limit this whole argument that they acted in bad faith, that they were terrible people, 404B. And unfortunately, the record, the first bench trial that we had during the opening, it's indiscernible, but 404B, I talked about it, and I can't keep standing up and sitting down after every question. So that's just a reference to, she didn't say anything, but yes.
Okay, counsel.
Sorry, I apologize.
Oh, no problem. Thank you both for your arguments this morning. The court will take this matter under advisement, issue and a decision in due course. The court is adjourned.